An Aurora police officer is now facing one of the most serious criminal charges possible after a grand jury indicted Officer Matthew Neely in the death of Rajon Belt-Stubblefield. The indictment charges Neely with second-degree murder and manslaughter in connection with the deadly shooting. The indictment is rare, but it also comes at a pivotal moment for the Aurora Police Department, which remains under a court-enforced consent decree requiring reforms after findings of unconstitutional policing practices. While prosecutors say the grand jury found probable cause to bring these criminal charges, Officer Neely is presumed innocent, and his attorney says he acted in lawful self-defense. Joining us now to help unpack what this case means, for Officer Neely, but also the justice system and for police accountability as a whole, is our legal analyst, Whitney Traylor. We're so glad that you're here. Let's start with how unusual this is for a police officer to be indicted in the first place.
Yeah. It's very unusual, primarily because DAs give a lot of deference to police in these split-second decisions. So we are seeing this now more and more, obviously with some of the police accountability across the nation, and of course with body cams, we're seeing that more and more, but it's still ultimately fairly rare.
And can I ask you why they decide to do the grand jury? Because, everybody, I've talked to a lot of folks in the community, and they're like, well, they didn't do that with Kylan Lewis, right? They decided, the DA themselves, just not to file charges. But in this particular case, they took it to a grand jury.
Yeah.
Where's the determination in which path you take?
Well, it's always difficult, and this is a rub that DAs have had for years and years because they have to work with law enforcement so frequently. They generally have a good working relationship. So to come and actually press charges against those folks creates a political issue. It creates a lot of difficult situations. And then to not prosecute then opens them up to community criticism as well. So the DA really, some people say, well, they're punting it by presenting it to the grand jury. And there's some validity to that argument. And on the other hand, the fact that the community is making this decision ultimately there's some benefit to that. So it could be a punt, but ultimately the grand jury came back with these charges.
And now it is in the hand of the prosecutors because they have to go through a trial here, and they charged Officer Neely with two separate charges, second-degree murder and manslaughter for the same shooting. Let me ask you, why file both? You see that often, right? We saw that with the paramedics in the Elijah McClain case. There were multiple charges. Same in this instance. Why do that?
Well, I think it gives the jury a little bit of an off-ramp so that they can find one or the other. And of course, the murder charge is going to be, it's a second-degree felony, and it's going to have a higher standard that knowingly he knew that this was a substantial likelihood of death, as opposed to acting recklessly. So the difference is the mental state of the officer. And so if they didn't find knowingly and there wasn't this lesser charge, it would be not guilty. So now they have both options. So it'll be one or the other or none.
And looking at the details of this case, how strong is the self-defense? Right, we know that's what they're going to argue. So, how strong of a defense is the self-defense?
Well, it's going to be difficult. This jury is going to have a hard time kind of going through this self-defense. There's a lot of things that this officer didn't do properly. He didn't announce himself. He didn't. Apparently, I think in the indictment they said that at some point he tried to holster his pistol to get his baton, but he couldn't get it in the holster. So that's why he didn't get the baton. That's an argument to say, hey, at that moment, that officer believed a lesser means was an option. The issue of shooting 3 times. Now, they are taught to, when they shoot to kill, to keep shooting until the threat is eliminated. Here, was the second and third shot necessary? So that's going to be an issue for the jury as well. So this is not a clear-cut case, but I think there's, of course, the prosecution has the burden of proof. So it's going to be a difficult case.
Finally, what do you think this means for APD as a whole, who's very much still, in the heart of this consent decree? after the shooting of Elijah McClain, lots of biased policing that has taken place along the years. This is another strike against a department that has seen a lot of strife.
This department has had a lot of issues. In their defense, since the consent decree has been in place, they have been improving. But there's still substantive issues within the Aurora Police Department. And so I think this will have two effects with regard to the consent decree. The practical effect, this will obviously be included as they go about their reviews, and obviously we'll have to see if there's a guilty verdict. And then, of course, the court of public opinion. The Aurora Police Department is not looked upon favorably, and I know they're working to try and change that. These type of events, these fatalities, continuing to kill people, if it's deemed unjustified, is going to continue to put a mark on this police department in the public eye.
And we did hear from the managing partner with the consent decree, and they said they're not ready to relinquish, their rights on what they're doing for the department. So that will continue. Whitney, thank you for the conversation as always. It feels like we'll be talking about this for a while. Yeah. There are no hearing dates that have been set yet in this case. So of course, you'll be the first to know when we hear anything new.